You two are so prompt. I hope you got to eat lunch.
I had an apple.
That's all you had for lunch was an apple?
Yes.
Oh, that's
Butternut squash soup for me. It was delicious.
okay. The soup sounds a little bit better than Jeff's apple for lunch. Dr. Tretsky, did you have any cookies?
No, I'm becoming a big fat slob, so I limited it to semi-healthy stuff. Had an avocado.
Oh my God. You and Jeff, avocado, an apple for lunch.
I also had a hot dog, but I'm sticking with the avocado.
This meeting is being recorded.
All right, let's see now. Do we have everyone here? I have Jeff, 1, 2, 3, 4, 5. Who's this? Mark. Donald's here, so. All right, we have everybody back here. I guess I'll call us back to session. There we go. There's Glenn. Glenn, what's up with the sunglasses? You're being extra cool today. All right, so we have everyone here now. It looks like we have quorum. Shar, do we need to take roll call again?
No, it appears that quorum is present.
All right. Well, let's go ahead and before we go on to item number 11, it was brought to my attention that we didn't really comment that much. We didn't take a position on AB 1733, which is the state bodies and open meetings where they're making adjustments. And I didn't know if we wanted to have a motion and then perhaps take a vote for either supporting the AB 1733. That was very poorly said. Does anybody have a stance one way or the other?
Well, I'll make a motion that the board supports AB, which one is it? 1733, 1433? 1733. Yes, I would motion that we support that.
And Board Member Sandra Sims, I second the motion.
Okay. Do we need to have public comment first before we take a vote?
Yes, that's right. And any comments from the board, and then a vote.
All right. Does anybody from the board have any comments before I open the Q&A up for public comment? Nope. All right, Madam Moderator, if you could open up the Q&A for public comment, please.
All right, I've opened up the Q&A panel. If any member of the public would like to make a comment, please type comment using the field in the lower right-hand corner of your screen and send it to all panelists, or you may simply raise your hand. We're displaying instructions and we'll give you a moment. All right, I see no requests for comment at this time. Shall I close the Q&A panel?
Yes, please.
Okay, it's closed.
All right, I am now going to do a roll call vote for the motion to support AB 1733. Donald Yu.
Aye.
Dr. Tretsky.
Aye.
Ms. Sims.
Aye.
Dr. Pruitt.
Aye.
Dr. Kawaguchi.
Aye.
Dr. Garcia.
Aye.
Ms. Brandvine is absent. Ms. Linden is absent. Mr. Moridomi.
Aye.
Dr. Wong, aye. Motion passes 7-0. Okay, thank you. Now we're going to move on to item 11. There's a lot of different items in item 11, and I wanted to make a suggestion that for all items except for 11A III and 11B III, that we could just accept them as the reports that we received, unless you wanted Shara to go over each individual part, or if anyone had any questions about any of the sections other than A III and B III.
That works for us unless there are particular questions that the board members would like to pose. And then, of course, we can take full public.
Too, yeah.
Yep, full comment after the presentations.
So everyone's comfortable with reports and has no questions right now. All right, so if we go ahead, Shar, if we could go ahead and start with our first presentation, 11A III, presentation on enforcement citations and advertising.
Fantastic. I believe that Terry will be starting us off, and then I apologize. I believe lead enforcement analyst Terry Villarreal will start us off, and then enforcement analyst Brad Garding will continue the presentation on advertising. Terry, please take the floor.
Hi, good afternoon, everyone. I hope everybody had a wonderful and really quick lunch. So today I'm going to present information on citations and what they're all about and how the board determines when to issue a citation. What is an administrative citation? An administrative citation is an enforcement action that is not a discipline, does not seek to suspend or revoke a license. It merely imposes a monetary fine and/or an abatement, an order of abatement. These are public and they are posted to our website.
I'm sorry, did you want to show the PowerPoint as well?
Yes, we do want to show that. I apologize. I didn't notice that was not up. I was looking at my screen instead.
This is the moderator. So Terry, I can make you the presenter so that you can share your screen.
You know, I don't have the ability to do that because
okay.
So I have to rely on you all to do that, the moderator to do that.
Okay. I wasn't aware you had a separate presentation. So is that something that you can email to us?
Or Terry, if you can drop it into the chat, the staff technical chat.
Sure. Can you give me a minute to do that, please?
Of course, thank you.
So the presentation is in the chat. I'm not sure if you're able to reach that, Madam Moderator.
I'm just downloading it. I'm just downloading it.
Okay. Okay, perfect. Here we go.
Okay, and Terry, just let us know when to progress the slides, please.
Okay, I will do that. I'm going to start over because I forgot to mention the introduction, so let me do that. I am Terry Villarreal, the lead enforcement analyst for the Board of Optometry. Today I will be presenting a high overview of the administrative citation. The purpose of this presentation is to provide a little education about the board's authority, possible violations, and process for citations, and what role the board members themselves play in the citation process and when. I want to encourage you to ask questions. However, I ask that you please don't narrow your questions down to specific violations or a known case. Okay, can you advance to the next? Okay, and please to the next slide. Okay, so what is an administrative citation? An administrative citation is an enforcement action that is not a discipline, does not seek to suspend or revoke a license, but merely imposes a monetary fine and or an order of abatement. And these are posted to our website. The next slide, please. What is the authority to issue administrative citations? The Business and Professions Code, or B&PC Section 125.9, authorizes all agencies within the Department of Consumer Affairs to issue citations for violations of their respective licensing laws or regulations. This section specifies a citation may include a fine for up to $5,000. Next slide, please. So this slide talks about the board's authority to issue citations. The BNPC section 2556.2 H1 indicates the board can issue a cite and fine to an optical company, an optometrist, or a registered dispensing optician for violations of section. Business and Professions Code Section 3095 indicates the board may establish a system for the issuance of citations and the assessment of administrative fines as deemed appropriate by the board, which we have done in the following sections. The California Code of Regulations, or CCNR Section 1576, which allows the board to issue a citation to an optometrist license. And the CCNR Section 1577 allows the board to issue a citation to an unlicensed person for the practice of optometry. These laws are in place to protect the public by exercising its licensing authority and disciplinary functions. Whenever the protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be paramount. We utilize these laws to bring licensees into compliance and or stop unlicensed activity. Next slide, please. Citations are issued when a violation can be proven. Again, they bridge the gap between education letters and the initiation of formal disciplinary action. We take into account several factors. There is no real potential for client-patient harm. The act does not demonstrate potential unfitness to practice by the licensee or registrant. The violation may not be ongoing, and it's minor or technical violation in nature. Next slide, please. So this slide explains what minor or technical violations are. Fail to register for a fictitious name permit, fail to apply for a statement of licensure, fail to notify the board of an address of record change within 30 days of such change, fail to cooperate with a board investigation, failed to post a license in public view, practicing with an expired license or registration, failed to provide a patient with a prescription at the end of their exam, failed to provide a receipt for services rendered at the end of the office visit, advertising violations, misrepresentation, for example, use of doctor without using the acronym OD at the end of the licensee's name, or failing a continued education audit. There are probably many more violations that could be considered a citable offense, but the list includes some of the most common violations that we issue citations for. Okay, the next slide, please. What is our level of burden of proof? The executive officer and enforcement staff can issue a citation based on the preponderance of evidence. What does this mean? A preponderance of the evidence is the standard requirement in most civil cases. The standard is met if the assertion of fact is more likely to be truer than not. The evidence collected is more than 50% true. As a rule, enforcement staff tries to meet the burden of proof at the level of clear and convincing evidence, which is substantially more likely to be true than not, more than 70% true. The reason for this is that if the cited party appeals to an administrative hearing, the stronger the evidence, the more likely the board will prevail in the case. Next slide, please. What is the range of fine amounts per program? The Optometry's program fine amounts range from $250 to $5,000 and are classified according to the nature of the violation, as referenced in the Code of Regulations, the California Code of Regulations 1579. There are 3 different causes for citation that can be issued. Class A ranges from a minimum of $1,500 to $2,500 for each violation. Class B ranges from a minimum of $500 to $2,500 for each violation. Class C ranges from a minimum of $250 to $2,500 for each violation. Each citation may contain multiple violations, so the total fine amount may be a much larger number. In addition to the specific class ranges, a citation can be issued for up to $5,000 if certain circumstances apply. For example, the citation involves a violation that has an immediate relationship to the health and safety of another person. The cited person has a history of 2 or more prior citations of the same or similar violation. The citation involves multiple violations that demonstrate a willful disregard of the law. The citation involves a violation or violations against a senior citizen or disabled person. The citation involves fraudulent billing submitted to an insurance company, Medi-Cal or Medi-Cal programs. The Optician reprogram fine amounts range from $100 to $5,000. When assessing a fine, staff gives due consideration to the appropriateness of the amount of the fine with respect to factors such as gravity of the violation, the good faith of the licensee, and the history of previous violations. Okay, next slide, please. What is the process to issue a citation? After an investigation is complete, the board staff drafts a citation and fine for the executive officer's signature. Citations identify the codes that allegedly were violated and contains a summary of the events and circumstances surrounding the alleged violation. On occasion, citations may include an abatement order to correct a matter. For example, submitting an address change, posting a license for public view, or correcting an advertisement. Board staff serves the citation to the cited party's address of record and tracks the citation for compliance or appeal. The cited party has 30 days to pay any fine imposed, comply with any abatement order, or appeal the citation. If the fine is paid, the matter is closed. If an order of abatement was also incorporated into the citation, the cited party must demonstrate compliance unless a later date for compliance is specified. Next slide, please. What is compliance and non-compliance? Compliance. If a citation was issued with only a fine and the fine is paid, the case is closed. If a citation was ordered with only an abatement order and compliance is met or the violation has been corrected and confirmed by board staff, the case is closed. If a citation was issued with a fine and abatement order and compliance is met for both, the case is closed. For non-compliance, if a fine is not paid or appealed within 30 days, board staff will place a hold on the cited party's license or registration renewal and will initiate a series of demand for payment letters. If the subject fails to respond to the third and final demand letter, the case is referred to the Franchise Tax Board for collection. If an abatement order is not complied with, the board has the option to file an accusation with the Attorney General's office for failure to comply with a citation abatement order. The case would then follow the regular disciplinary process. Next slide. What are the appeal options for the cited party? There are 3 options to appeal a citation. Request an informal conference with the executive officer or their designee, request an administrative hearing, or request both an informal conference and an administrative hearing. Informal conferences are held by telephone, by teleconference, or in person. If the executive officer decides to withdraw the citation and fine, the citation is closed. If the executive officer affirms the citation and fine, the subject is required to pay the fine unless a request for an administrative hearing was filed. If the executive officer modifies the citation and fine, a modified citation will be served. The subject will then be required to pay the modified citation unless a request for an administrative hearing is filed. Requests for an administrative hearing are forwarded to the Attorney General's office. The Attorney General's office will be a DAG, a Deputy Attorney General will be assigned and schedule a hearing date with the Office of Administrative Hearings. After hearing the case, an administrative law judge will issue a proposed decision for the board to consider. Board members are not involved in the citation process unless an administrative hearing is requested to appeal a citation. The case goes to hearing, and again, a proposed decision is received for board members to review and cast a vote on the case. Citations are not considered formal disciplinary actions since the license is not being revoked or restricted. Instead, board members are provided statistical data regarding the issuance of citations at scheduled board meetings. This concludes the presentation on citations. Are there any questions?
I have a question. Oh, Dr. Turetsky, you can go first. It's Dr. Turetsky, then Dr. Garcia.
Okay, hi Terry, it's Dave Turetsky. Quick question, and this, I don't even know if this is apropos, but I was at my dentist's office earlier in the week, and you were mentioning about citations not giving a receipt at the end of the exam. I go in, my dentist does the hygienist does the cleaning, the dentist comes in, takes a look, I go outside, and they say, you're all done, you know, we'll take care of it with your insurance. If that happens at an optometrist's office, is that a citable offense? Because there wasn't a statement given that on the charges, even though it was going to be billed to insurance, and I'd be getting something from the insurance once it was over.
I would say not necessarily. It could have just been a miscommunication, or it could have just been forgetfulness on the doctor's, on the office's part. You know,
Oh no, this is the way This is the way they've. I've been going to this dentist for 20 years. They they never give you a receipt. And I know that that's common with a number of optometrists that I'm aware of who don't have, if they're going to be billing an insurance plan and there's no charge to the patient just walks out the door. They don't give them anything. So that is a citable offense.
Well, the first step in relation to this would be for the patient to file a complaint with us. And we would,
Okay.
Conduct an investigation, and we would contact the licensee, the subject, and ask why they aren't providing receipts. So that's the route we would go at first, to give them a chance to explain their side of the story and find out why they are not providing receipts.
All right. It just interested me because, as I said, my dentist hasn't given me a receipt in 20 years. So I was just wondering how that works.
If I may
would
say
also
something, I'm sorry to interrupt. This is Brad Gardy. Yeah, so the issue with the receipt is there's a specific law that applies to
Brad, can you say that again? I think we lost you.
Oh, yes. So Business and Professions Code 3076 that mandates that a receipt is required to be given at the conclusion of an eye exam.
Right. I think I had Dr. Garcia's hand and then Mark's hand.
Hey, Terry, another great presentation. We appreciate it.
Mhm.
I think it's really helpful to have these trainings. I just wanted to point out, I think I did mention it last time on the previous training, that administrative citations on page 1 of your presentation, it says basically merely imposes a monetary fine and or order abatement. So while that is true, I think that maybe not be completely accurate, because it is still reported to the National Provider Data Bank, I believe, and correct me if I'm wrong.
No, you're right. That's correct.
Okay, so I think that's important to say that, because all the presentations we've had from staff are very good, but it makes citations sound so benign, and they really aren't. And a lot of these things, even if a licensee complies and the abatement is closed, those things still keep rolling. So it's a 5-year long list that you're put on, even if it's something very innocuous and which may on the surface seem pretty benign. I think we should be transparent and say that there are other implications to these citations, and it's not just merely imposes a monetary fine or order of abatement. There's a lot more that's involved that happens afterwards. So I think we should correct our trainings to reflect that.
Okay, we can add that information to our to this presentation.
Thank you.
And also, I did want to mention, I started to mention before Mr. Garding provided the law in relation to receipts. We can only speak to what we do here. We can't, what the dental board does. We can't really talk, speak about that. But Mr. Garding did provide the law, so thank you for that, Brad.
Yeah, Mark, you had your hand raised also.
So, Terry and Cher, thank you for putting this on. I think this information is very important. I didn't know about these citations until probably a couple years into my tenure as a board member, that there are all these other kind of enforcement actions. And Dr. Garcia is right that these citations are an important enforcement tool when in the event of multiple violations. I think Dr. Garcia kind of answered this, but I'm a little confused in that. So if someone gets a citation, if a consumer looks that person up in Breeze, am I correct that citation does not show up on their Breeze record, or does it show up?
No, they are put on our website. They do show up. They're added under enforcement actions on the board's website.
But not on, because on Breeze, for example, they have disciplinary actions. and that's the DCA website. Does a citation show up there?
On DCA's website?
So Terry, if we were to do like a license lookup, like if someone were to look up Lillian Wong, optometrist on the Board of Optometry website, and if I had a citation, would it show up under my license search number? I think is what.
Yes, it would.
And it would show up for 5 years, and then after that, it's gone.
That's correct.
Right. So yeah. So then also these citations, like Jeff was saying, they're not as benign as just like getting a ticket, because if you apply for another job, your future employer or the place that you're applying for a job will ask if you have had any kind of disciplinary measures or citations on your record, and everyone would have to report it. So it may or may not prevent someone from getting a job. So it's not quite as benign as like getting like a parking ticket or something.
That's right. Yes. I know that it can infect, it can affect your insurance.
Mhm.
You know, it can affect a loan that you might apply for. You know, it's not a formal discipline, but it definitely has repercussions.
And I also appreciate the other item on the agenda where it's reported to us the citations that the EO has issued. I don't think we have ever seen that before, at least on my tenure, about the citations issued during any period of time. And it's, you know, I agree it's totally within the EO's authority and it's probably more efficient that way. But I'd like to know what staff is doing in all aspects of their enforcement powers, not just probation and denial of licensure. So thank you very much for this presentation. It's very, very helpful.
Sure, you're welcome.
Hey Terry, one more follow-up question. Mark's question kind of sparked this in my head. So are all other boards treating citations the same as we are?
You know, I can't speak for all other boards, but overall, I believe, yes, they are. If you look at other boards, a lot of them, if you look on their website, a lot of them do list citations on their website, you know, in a license lookup. I don't know if every DCA board and bureau and committee includes them, but I know a large percentage of these departments do.
So it's not a mandate.
I don't believe it's a mandate to put this information on you know, each board and bureau's website. I could be wrong. I don't think it's a mandate. You know, in doing some research for other projects that I have been working on lately, I have been looking on other boards and bureaus websites for citation information, and there were a couple where I couldn't find any listed, and I don't remember which boards and bureaus those are off the top of my head. But yeah, I don't know that it's a mandate.
So then a follow-up question would be, so is it doing our due diligence to post citations that may have been, like you had mentioned, that list where they're fairly minor, and then the licensee complies, and then the case is closed? Isn't that different than the situation where a licensee is at risk of losing their license for a greater level of violation? So is there any way to discriminate between those two levels and treat them differently, and not pull them all together and list them as the same on the website and make them equally reportable?
Well, if I'm understanding your question correctly, what we currently do is if we are informed, you know, of a licensee doing something they shouldn't do, the first step for us is we write to them and we ask, you know, why are you doing this? This is what the law says. Can you please explain? And sometimes the licensee will, you know, they write us back and they'll say, I wasn't aware that I was doing that. I've corrected the issue. You know, please check my website. Please, you know, here's a picture of my business card. Here is a current picture of my advertising, for example, on my front door. You know, whatever the issue is,
Yes.
then if they're in compliance, then, we close the case. But citations are public, they're public information. And if we can't get a licensee to comply, then that's when we go the citation route. If the allegations are not, don't warrant the case being sent to the Attorney General's office.
Carrie,
Yes.
hi. This is the Randy Love, the Assistant Executive Officer. If I can step in a little bit about and speak to why citations are posted on the website. It may be that there is a mandate. I'm not positive off the top of my head, but we can look into that for you. But citations are public information. They are a matter of public record, and whether or not the violation is minor or less minor, I don't know that as a public protection agency that we should be looking at hiding public actions against licensees by not posting them and sharing them. And as far as posting them to the National Provider Data Bank, the federal government specifically has asked that we do that. So if we are not posting them to the NPDB, we run the risk of being in violation of their requirements.
Randy, thank you for the clarification. Thank you, Terry. I just wanted to make sure that our trainings are clearer.
Sure.
I appreciate that. Thank you.
Yeah, I understand that. We can make, if the citation presentation wasn't, that clear, we can work on it a little to make it a little more clear.
All right. Does anybody else have any questions for Terry?
I don't know if this question is appropriate for Terry or for the next presentation about advertising, but I'll have a few questions about how advertising violations are charged. So I'll hold off until the advertising presentation, but Terry, you may want to listen in case you're the expert on that too, on the charging of citations.
Yeah, sure. Brad, another enforcement analyst, Brad Garding, is going to do that presentation, and you can ask your questions at that time.
Okay. All right. Well, thank you, Terry. Why don't we go ahead and let Brad do his part of the his presentation on advertising.
Hello, board members. Thank you for. So can we go to the next slide? My name is Brad Garding, and I'm going to.
Uh-oh. Hey, Brad, you cut out.
Yeah, I apologize for that. Can you hear me better now?
Yes.
Okay, excellent. Okay, so for my presentation about advertising violations, let's just start off with defining what advertising is. It's advertising is any form of public communication used to bring the practice of optometry or opticianry to the attention of the public. And advertisements may be found in store signs, on the radio, on television, etc., and any representation on the internet. Next slide, please. For the board, we do have a culture of enforcement, and the main focus of the board and for enforcement in particular is to protect the public. Secondary focus is to educate our licensees so that they can all be in compliance in order for the consumer protection goals. Excuse me. The board attempts to gain compliance before anything else. Citations are really the last thing we would do if we can't get compliance. Now, the reason why advertising violations are important is because they can lead to a deceived or defrauded consumer. Therefore, gaining compliance is more important than issuing citations or other actions. Okay, next slide. So I'll go over some advertising laws that apply to optometrists. This isn't an exhaustive list, but it covers a lot of the ones that we see most often. So when an optometrist is practicing under a false or assumed name, this typically applies to fictitious names, say a practice name. You would need to get a fictitious name permit to advertise that fictitious name. And for fictitious name permits, any optometrist that's listed on an F&P must be included in any advertising. The use of doctor requires the use of OD, OPT, or optometrist following that name. Holding oneself out as a specialist in eye disease, that's prohibited because of the healthcare implications of it. We want to have a level playing field for all the optometrists. They're all providing optometry services, so let's keep it at that level. So claiming a special knowledge of optometry is also not allowed for the same reason. Advertising without certificates. So this is similar to the F&Ps. If you're advertising your practice and you don't have a fictitious name permit for that, that could be a violation. If you're practicing at a location that you don't have a statement of licensure for, that could be a violation also. Let's see, moving on to free eye exams or price advertisements. Free eye exams you can advertise those, but in the advertisement, it has to be specified how you can get that free exam. So if you have an advertisement for a free exam, but you have to buy glasses from that location, that has to be stated in the advertisement. An optometrist is not a physician. A physician is a medical doctor or similar. An optometrist is a doctor, but not a physician. In general, false or misleading statements that can mislead the public. All your practice locations, you should have statements of licensure if you're practicing outside of your address of record under most circumstances. Registered name only. That applies to your practice name. Say you want to go by your middle name, but your registered name is your first and last name. You wouldn't be able to use your middle name in any advertising because you have to advertise only as what you're registered as. All right, next slide. All right, false advertising. False advertising is any public communication that contains a false, fraudulent, misleading, deceptive statement, claim, or image that's likely to induce, directly or indirectly, the rendering of professional services or furnishing of products in connection with the professional practice or business for which he or she is licensed. That's pretty basic. Okay, so next. Okay, so fictitious names. For licensure, fictitious names are required when you're using a fictitious name, and they must contain the word optometry or optometric in the title. And you can only advertise the name as it's issued on the F&P. And in any advertising for that practice using that fictitious name permit, all the optometrists that are listed on the application must be also listed in the advertisement. Okay, next slide. And practice name violations. So you can only use registered names, like I used the example of using the middle name. That comes into play here, but also for fictitious names also. On any signs, cards, stationaries, or other advertising, it must clearly and prominently identify the individual optometrist or optometrist. All right, next slide. Okay, so now we'll move on to the optician advertising laws. Registered dispensing optician cannot link their advertising to an optometry practice. In a sublease agreement, an RDO must only state that there is an independent doctor of optometry located in the lease space. For an RDO, it would be a violation if you saw something like schedule your appointment with Dr. So-and-so. That's not allowed. You can't link the practices together. So price advertisements for RDOs must disclose any fees that are associated in similar ways that the fee-related advertising for optometrists. It just has to disclose why or what fees and for what. So for opticians, advertising eye exams is not allowed. And RDOs are not allowed to advertise or collect fees for eye exams. And they're not allowed to furnish eye exams. They're not allowed to state that they can provide those services. In addition, spectacle lens dispensers and contact lens dispensers may not advertise nor provide optician services apart from any RDO. Okay, next slide. So how does the board address advertising violations? So an enforcement case is opened, and an enforcement analyst sends an educational letter to the licensee alerting them to the violations. So we also include a due date on there so that we can get the conversation going on how to come into compliance. There's typically a lot of communication going back and forth in order to get compliance for advertising violations. And so we want to give the licensee every reasonable chance to come into compliance. So if compliance is obtained, then the case just gets closed. If compliance is not obtained, we can issue an administrative citation. Okay, next slide. Okay, so if a citation is issued, the board has determined that compliance has not yet been obtained. And citations are not intended to punish the licensee. They're simply a tool used for compliance. And so if compliance has still not yet been obtained, the analyst will continue with efforts to gain compliance from the licensee. One thing that's important, some of the consequences of not complying with the citation is that the license are not able to be renewed until that compliance is obtained. And depending on the case, if compliance cannot be obtained, the case may be returned or referred to the Attorney General's office for formal discipline where an accusation could be filed. Okay, next slide. Okay, so the required reporting of citations. The citation is public information for 5 years and will be provided to anyone who requests it. The citation is posted on the licensee's public license profile for 5 years. And the citation is available through the board's website through the Disciplinary Enforcement Actions link on the Consumer tab. The citation is also required to be reported to the National Practitioners Data Bank, which is federal law to do that. Okay, next slide. So this slide was added to help address Dr. Garcia's concerns of educating our licensees. So some potential consequences of citations are that an optometrist could be depaneled from an insurance panel, and it makes it more difficult to obtain an SBA loan, which is small business loan, and it makes it more difficult to obtain optometric equipment from sellers. And all of these consequences are outside of the board's control. The board doesn't even know about these things unless insurance lets us know, which sometimes they do. But we don't have any input on that. Okay, next slide, please. Hey, thank you for your time. More trainings will be provided in the future. I'd like to open it up for questions. Mark, if you have, if I didn't answer those questions you had, please go ahead.
One thing I'm curious if Lillian, I can go,
Okay.
is what thought, if any, or what consultation you do with our legal department when deciding how to charge. And the hypothetical I can come up with is, let's say I'm an optician or an optometrist, and I advertise that my eye exam will cure cancer. And I do that in Alameda County. And then compared to someone else who does that in all 58 counties. Would you consider the one who does it in all 58 counties is that one violation, or is that 58 violations, or what, how do you go about deciding what a violation is when it comes to advertising?
Okay, so typically how we would investigate that, or we would look at that, is that does a violation exist, yes or no? So we could only really charge for one count of violation of false and misleading information in that instance. But if they're saying this can cure cancer, this is more likely to go to the Attorney General's office for an accusation. That's more egregious than something like you don't have OD at the end of your name.
I see. Because conceivably, I guess you could charge it 50. I've worked for agencies where we would charge as 58 counts, and but
Sure.
okay, I think you've answered. You turn that into an accusation and address it that way. I see. Okay. All right. Thank you.
Thanks. Yes, Dr. Tretzky.
I'm wondering how enforcement decides who's going to actually end up having to pay for a citation when a violation is readily corrected. I know of a personal friend who about 6-7 years ago was working for an ophthalmologist, and the ophthalmologist printed up business cards that stated that this person was a contact lens expert. And that made its way to the board. And the doctor was told, you can't be an expert. And the doctor explained to the board that I didn't even know those cards were out there. They got rid of the cards. They changed it to, Dr. Smith, OD, and everything was fine. And there was no citation or anything. But yet other people might be advertising themselves as, Dr. John Smith, eye care provider, not optometrist. And those people get $1,000 fine before they're done correcting things. It seems like it's inconsistent. And I'm wondering, is there a way that enforcement does things so there's consistency across the board?
If I'm
One technical issue here is.
Brad.
I'm sorry, go ahead.
It's okay. Executive Officer Murphy. So there is a consistency. What we ultimately want to do with a citation and a fine is to compel compliance. If compliance is reached before a citation can be appealed. And if at that informal conference, it is concluded that the citation was promptly corrected, then I, as the executive officer, your sitting executive officer, has the opportunity to modify that citation and remove the fine or withdraw the citation altogether. So certainly in my tenure, I try to use my discretion in order to make sure that we are using citations and fines as a way to gain compliance, not as a punishment, but as a way to gain compliance. So if compliance is gained through the investigation process, and there wasn't a willful desire to mislead consumers, then of course it's entirely possible that a citation can be withdrawn. that a fee will not be levied against the licensee.
Okay, so the only way it would get to the executive officer would be if the licensee requested that informal conference. Otherwise, the enforcement folks are going to follow procedure and do what they're going to do. And if the licensee just pays the fine, and the fine and the citation will then be recorded and put on their record. If the licensee does not request that informal meeting or to have an ALJ review it, something on that order, is that how it happen?
Normal procedure does include making the licensee aware of their opportunity to have an informal conference in order to appeal the citation amount or the citation itself. So our normal procedure is to let folks know this is where we are. You may ask to have an informal conference, at which time your citation can be withdrawn, can be reduced, and then. So the standard procedure is that each licensee is made aware of their opportunity to have it fought. So it's not as if you just don't know, you aren't going to then fight it. You're clearly given the opportunity to have an informal conference with the executive officer or to request a hearing with an administrative law judge.
Do you have many of these informal conferences?
I do. And it was really pretty like a great staff effort. We had a licensee maybe about a month or two ago who needed a language translator. And so it was very interesting for us to go through DCA's language translation and conduct the informal conference. So yes, we often do have these. I then of course weigh that citations are never issued without the signature of the executive officer. So it's not as if an enforcement analyst can simply decide that a citation should occur. All citations do run through your executive officer.
Okay, thanks.
I think Jeff has his hand up also. Oh, Jeff, you're muted.
There we go. Thank you, Brad. Great presentation. Thank you for making your slides a little more accurate. I appreciate that. I have a question. I don't know the answer to this, and it's really not for any decision making. But I brought this up last time with the issue of specialists. You know, in our profession, we do have specialists that pursue that title. They go to become a fellow of the American Academy of Optometry. And then above and beyond that, they can apply to become a diplomate. And I believe there are 7 sections, and it requires quite a bit of test taking and case studies. It requires interviews, and it requires the diplomate to basically reapply every 5 years. So there are a lot of restrictions on that. And I just think that there are certain optometrists in our field that deserve that ability to call themselves specialists. And my question is, are other states not allowing optometrists that have that level of specialty and that title? Are they not allowed to use that title in their advertising or in their name? So just a question. Maybe something worth looking into.
Certainly, yeah. Thank you for bringing it to the full board, Dr. Garcia. I think you did make some good points at the committee meeting. I think it does warrant being agendized at committee or full board. We have not inquired with our ARBO executive officer membership as to their uses of specialist, but I think that it will help in bringing this to a full discussion if we do. So I think that's certainly clear. I've got my future agenda item that we should do some research nationally to figure out what other jurisdictions and internationally other jurisdictions do to recognize those optometrists who do take a particular course and do become do have advanced knowledge in a particular specification, and then to bring that to the committee to discuss and then possibly to the board for recommendation, if that so pleases President Wong.
I think that sounds like a great idea. Thank you, Shara. Oh, Mark. Mark, you're muted.
I just want to reiterate my thanks to the executive officer and staff for bringing this really important presentation, just like the other. I think this presentation, oh, and I also want to thank the other agenda item where you report the citations. I think this underscores two things. One is that we need to have a great executive director that has, as we can see, a lot of power and who can be consistent in her decisions on these citations, because very rarely will we see them at the board level. And second, appropriate to the other report, it's incumbent upon the board members to see the citations, to be informed about the citations that are being issued, and to do the best of our ability, make sure that they are consistent. If we're charging $5,000 because someone doesn't have OD on their business card, and that kind of case is happening over and over again, then we should comment and ask questions about that. But anyway, just thank you to staff and the board.
Glenn.
I wanted to echo what Mark just was talking about. When Mark was president and I was vice president, I think we came to a realization that there was a lot more actions going on with our staff that the board in general did not fully understand, and in some cases didn't realize was going on. And so these trainings have been great because I think it really helps all of us to understand the work that's going on, ensuring consumer protections, not just what we discuss in board meetings, but there's a lot going on with our staff as well. So thanks for sharing all the information with us. It's very helpful.
Oh, Joe.
Yeah, I was just wondering, I don't know if this is necessarily, I guess, in the same vein, but kind of going on with what Dr. Garcia was saying as far as the use of being a specialist in a particular area. I know a lot of, if it could, or if it's appropriate, included in looking to see what other jurisdictions do, could you potentially look at the phrase of optometric physicians? Because I know there are a lot of jurisdictions out there that exclusively just use optometric physician. And I wonder if it is in the best interest for us to completely exclude it. And so I would, like I said, I don't know if it's appropriate or this is a right avenue, but maybe when looking at the other jurisdictions, throwing the optometric physician in as well.
Anybody else have any other comments? Oh, well, I wanted to thank both Terry and Brad for some great presentations. And they're very, very informative. So thank you. And I think we need to move on to section 11B III, update on immunization certifications and processing, please.
Lillian, before we get to that, is there any public comment on these?
I thought we were doing public comments at the end of all. Oh, that was
Okay,
it. Yeah.
that's
So
fine. I just, it's up to you.
oh, I thought. Oh, okay. Let's go ahead. It's up already. Let's go ahead and open up public Q&A for public comment, please. Thank you. Thanks, Mark.
All right, so the question and answer panel is available. If any member of the public would like to make a comment, please type comment using the field in the lower right-hand corner of your screen and submit it to all panelists, or you may simply raise your hand or displaying instructions and we'll give you a moment. All right, I see no requests for comment at this time. Shall I close the Q&A panel?
Yes, please.
Okay, it's closed.
All right, now let's go on and move on to 11B. Update on immunization certifications, please.
Thank you so much, Madam President. So at this point, we will bring up Natalia Leeper, who has been the lead for our licensing process on both optometry and opticianry for the last few years. Natalia will give us a brief verbal update regarding immunization, and then we'll spend a majority of her time doing our presentation on optometry reinstatement after cancellation. Natalia, if you'll take the floor.
Of course. Good afternoon, board members. So this is coming to the board from the Practicing and Education Committee. We went over this briefly with them. We're trying to determine whether or not the course required to have the immunization certification, the APHA Pharmacy Immunization Delivery Certification training program, be available for CEs. It was brought up during the PEC meeting that it was believed to be that glaucoma was also accepted as CE. But upon my investigation and research into the Wayback Machine of 2008, it was inconclusive. When I looked at audit reports, CE audit reports done by our enforcement unit, there wasn't any determination on what caused a licensee to fail the audit. Basically, the reports were incomplete. So even ones that did say fail, to me, failed for multiple reasons, and it wasn't specifically stated why each one had failed. So we are bringing this to you, the board, to determine whether or not if we want to go ahead and accept this 20-hour course. Now, of course, only probably about 15 hours can be accepted, because 35 hours for all of our TPA licensees, or just most everyone, must have 35 hours of ocular disease. So only about 15 hours, I believe, are going to be able to be accepted as continuing education. So unfortunately, we would lose out on that 5 hours if we were to do this. And you could definitely use some of the 8 hours, which are part of the self-study, could be used towards our 20 hours of self-study. So if the board wishes, we can accept these hours as continuing education CE for their 50 hours for every 2 years, but that would be up to the board's discretion.
Can I ask a question, Natalia? Or
of course.
I'll ask the PEC member. So how many hours is how many?
Lost Dr. Wong.
Sorry, my Wi-Fi keeps on cutting out. Ignore my question from earlier. It wasn't pertinent. Never mind. Does anybody else have any questions for Natalia?
I do. It's Glenn. So, for doctors that may be taking courses for other types of licensure, such as punctal irrigation. I forget what it's actually called now. I have a certification for it, but anyway, so when they take other courses, we currently have been accepting them as part of their CE to the point where, Natalia, the point you made where they have to have certain CE that qualifies under their current licensure. Same thing with the glaucoma course. They could apply pretty much all of that course to their overall CE. Isn't that correct right now?
Yes. So but I think when you look at the course topics for the immunization courses, not all, I mean, some of it's like that storage, proper storage of the vials. And so I don't, so I maybe PEC should talk about this, but I know that when we looked at it in the past, when I was on PEC, not all the topics would fall in, some topics just wouldn't fall into any of our, wouldn't even fall into the general category. But I don't know, Jeff or Joe, do you, either one of you want to talk about that? How you came up with 15?
Sure. Pull up some notes here. Yeah, so during the last PEC meeting, we did discuss it. And I know it's been a topic of discussion for many years, way before I came on to the board. But the three of us, it's Dr. Pruitt, Dr. Chawla, myself, had some great discussion on this, and the staff was very helpful. And we felt that after discussing it, looking at the different topics that were in the immunization course, that a lot of it, maybe not all of it, but a lot of it did fit cleanly into our CE categories. And especially since it's something that's within our scope of practice, it only makes sense that we award CE to doctors who engage in this extra certification. So we came up with 12 hours, and that basically is because there's 8 hours of live training and there's 4 hours of self-study. So that was kind of an easy way to classify this. So we felt that 12 hours of CE would be appropriate. So that's what we instructed staff to do, and that's what Natalia was talking about, to go ahead and put that into a formalized proposal for the full board to discuss and act on.
And those 12 hours, they fall into specific like ocular disease treatment, or is this going to be 12 hours under general?
General.
So I want to step in. It wouldn't be considered general, which we would because general would be considered under ocular disease by how we have things set up.
Okay.
So it would be considered miscellaneous. So it's basically anything not related to the practice of optometry. So it would kind of fall into that category we've kind of created we've talked about, child abuse awareness, elder abuse awareness. It would fall into that category, and not necessarily under the practice of optometry specifically.
So Natalia, so you're saying ocular disease is our general category and separate from glaucoma?
Correct.
See, that doesn't
make sense to me.
I thought 35, so if you are TPA certified, I thought 35 of the 50 hours we had to complete was for treatment and management of ocular disease. So that 35 would include ocular disease and can also include glaucoma. And if you're glaucoma certified, then you have to have 10 hours of glaucoma, and right? So
yes, that's correct.
So I guess miscellaneous or general optometry is what we would accept.
That's my understanding, yes.
So general optometry CE is where the immunization would fall under that category versus the 35 treatment and management of ocular disease CE. So it's two separate. That was my understanding.
That's my understanding too.
So are we making a motion for support? I'm not quite sure what we're.
This is Natalia. I've been speaking with Shara over text, and I think for now, after just hearing what you guys have been discussing, I think staff wants to do a little bit more research. So I think you guys have been great on giving us a little more insight on, especially for the members of our professional committee who are not part of PEC. To give us a little bit more insight. I think what we've decided is we want to take it back, do a little bit more research, and then bring it back to PEC if that is acceptable.
Okay. All right, thank you. Sorry, it's my dog. All right. So then if we're done, basically, do we need to take public comment on, sorry. Do we need to take public comment on 11B III?
Yes, it's a good practice, just to make sure. Thanks.
if we could, oh, thank you.
All right. The question and answer panel is now available. If anyone would like to make a comment, please type comment using the field in the lower right-hand corner of your screen and submit it to all panelists, or you may simply raise your hand. We are displaying instructions and we'll give you a moment. All right, I see no requests for comment at this time. Shall I close the Q&A panel?
Yes, please.
Okay, it's closed.
So I think we're now moving on to item 11E. I think that's reports by Dr. Turetsky. What else is the other report by? Oh, and
You
Dr.
can put
Garcia.
on my reading glasses.
Dave, you're so young, you don't need reading glasses.
I really don't, because once you've had your cataracts removed, they can do amazing things with lenses. Shara, are you there?
Yes, I am, Dr. Turetsky.
Okay, so what would you like presented first? What would be the most appropriate thing? I've got Sid's report. I can discuss what we did at the Ledge Reg Committee. Where should we start this?
I think let's start with the report from Sid, and then we can move to your report from Ledge Reg, and then follow that up with Dr. Garcia's report from PEC.
Okay, so
if you so chooses to give a report today.
okay, so this is from Sid Brandvine, who's not with us, is the chair of the Consumer Protection and Outreach Committee, and she just gave me a brief couple of paragraphs to read to the board members. So a few of the issues that the committee had touched on: the boards developed new or refreshed current training for licensees and professionals, as well as the board. They participated in a pilot onboarding and training for new members to get them better up to speed on the regulatory and licensing processes, so new members can actively and knowledgeably engage in regulatory and enforcement discussions early on in their service. And they're also modifying the training for students and for the licensee community. And this was something that was really great, because most of us, when we first joined the board, didn't know much of anything, and it took a couple of years in a few cases to really learn how things were supposed to run. And it's nice to have this for board members, and the same training available for new licensees and students will be extremely helpful. Also looking at the board's own communication practices with a focus on what we say and how we say it. For example, reviewing current contents of letters and talking points for probationers, and what we send to the public or professionals through mailing lists. Sid also pointed out that we've already seen one action in the most current newsletter, and a list of non-compliant professionals and their enforcement actions was prominently displayed in that newsletter, and that actually got people that I know reading the newsletter for the first time in a long time. And Sid also said one additional priority was the sharing of legislative updates to better inform practitioners as to changes in practices within the state of California. So that's what I have from Sid. You can ask questions, but I don't have her answers to those. Regarding anything on that? The Ledge Reg Committee. At our last meeting, I think the main topic was the cleanup language to AB 1534, and that encompassed a lot of things. Basically, we want to make sure that the changes that are added, we had mentioned, for instance, the Stanton Optical enforcement actions. There are several loopholes that are in current legislation at 1534. Cleanup is going to take care of, it's going to enhance consumer protection. It'll close these language loopholes that allow entities to get away with potentially providing deceiving levels of care to the public, and it's also going to improve enforcement violations, which are compromising professional judgment and potentially patient care. So that was the main issue that we had discussed, and we also discussed ways of bringing stakeholders into this and meeting with other industry players, so we get a complete buy-in on this and make sure that this should be able to move through the legislature without a whole lot of difficulty. What did I leave out, Shara?
Nothing that immediately comes to mind, Dr. Turetsky.
That's all I've got.
Thank you. Dr. Garcia, do you have a report? You want to report anything about PEC?
Yeah, I will. Most of what I had to report, we already kind of talked about with the immunization, so I'll not rehash that. But I just want to first thank the staff for all the hard work they do for processing these CEs. There's hundreds of pages that come across their desk and need to be processed every month and quarter. I know Christina Eklund has done a great job with that. I had the unique experience of actually submitting my own CE. I just wanted to kind of, as an aside, mention that. So I went through the process myself, submitting CE and going through the steps. And that was a good learning experience as well. And again, Christina was really, really helpful for me as my first time to kind of answer questions along the way. But you know, it kind of also, and I already spoke to Christina and Shara about these things. There was a handful of things that I think, and staff was already working on fixing these. There were a handful of things along the process that either weren't in the instructions at all, or poorly explained in instructions. Something as simple as how you pay your $25 fee is not explained. So a lot of those things, you know, the staff was already fixing those. But you know, it was nice to be able to be the customer and see what the applicants are going through. I want to thank Dr. Pruitt and Dr. Chawla for participating on this committee with me. They're always there and they always provide great insight. But other than that, you know, again, we talked about the immunization CE. So, you know, that's been the majority of our major discussion. But I'd like to invite Dr. Pruitt to chime in, and if he has anything he would like to add, if he could do that now.
No, I don't have anything in particular that wasn't already covered. Just that, yeah, staff goes through a lot of presentations and puts it all together and does a great job doing that, so we can sort through the presentations, and that the lion's share of what took our time, the last excuse me, committee meeting was discussing the immunizations and how those that course or the steps that you need to attain certification could be counted towards your continuing education requirement. Sorry, my allergies are making it difficult for me to talk. Sorry.
Can I ask a question? So I don't know if this is really for PEC or if this is for Natalia. I just know that right now there are docs that are submitting their immunization certification certificates to the board. And number one, how do they know that it's been processed so that they can, once this the emergency order has been completed, that they'll still be able to complete immunizations? And then I think we as a board, because I don't think we've decided yet, we have to decide how we're going to designate that an optometrist has immunization certification. Because it could just be the letter I, but now we're just adding more and more letters to the end of our licenses. It's getting almost as many letters as there are numbers.
It's Natalia. Actually, I had included this actually as part of my licensing update for, I think it was like 11BII or I.
Sorry.
And that's okay. But definitely what we're doing right now is I've actually started issuing some immunization certifications. I've started processing through the beginning of January. And what is happening is, because it isn't in Breeze yet, this was super short notice, all of it's in paper, I am creating the certification, like little certificates, and I'm sending them out to the doctors. So it'll say certification for immunization, and we'll have the doctor's license number, including their current designation, TPG, TLG, whatever it may be, and then their address of record that we have listed on file. The plan eventually, and the easiest way, because this is the system we already have, is to add I at the end. So people who are now 2PG, who have their immunization certification, will be TPGI. That's not going to reflect until we actually get the process into Breeze. So for right now, they're going to get individual certifications, and they will be posted online on our website when I've approved them, so people can, like consumers and other licensees, can look and see who has been issued one so far. So that's what's going on, and that's currently the plan.
And do these docs have to like publicly post these certifications like their licenses, or it's just good enough that they just have them in hand?
We're requesting that they post them. Yes.
Thank you. All right. I don't have any more questions. Does anybody else have any questions for Natalia or oh my gosh, you guys were on a different screen. I have Mark and Glenn's hands raised. Sorry.
So, excuse me, as a public member, why is there a need to add letters onto a certain person's name when you get certified? I mean, we lawyers, we rarely put on JD, but we certainly don't put on our various criminal law or other specializations on the end of our names. So it's kind of a rhetorical question. Why is this done? It may be a function of the medical profession.
Yeah, this is Dr. Garcia. I just wanted to say thank you for asking that question. And Dr. Wong and I were talking about this just yesterday, that to me, it doesn't make sense to have this alphabet soup after our license number, because we have other things coming down the line. Then we're going to have more letters, right? As our scope expands, where does that end? Like Dr. Wong said, we're going to have more letters and numbers. It doesn't make sense to me. I don't think any other profession at all does what we do. I think our license number is sufficient. If you go on and look up our license number, it has our certifications. If someone's curious if we're practicing outside of our education or our certifications, it's right there. It seems to me, use your license number and keep everything else on the website for the public, for public protection, or for any other agencies that are curious. But to me, what we're doing now with all these letters is starting to not make sense.
And then, currently with Breeze, it is actually very easy to look up any doctor's license number. So the extra letters are becoming quite excessive. So great question, Mark. Oh, sorry, Glenn?
Yeah, so I have a separate thing, but let me address Mark's question, because at one point, a number of years ago, I know at least Dave and I were involved in trying to increase clarity for consumers so that consumers would have a good idea of what type of care they could obtain from a practitioner. But I definitely understand the points that are being made about it's getting to be too complicated, and it was always complicated for consumers to begin with, and it's just getting worse, and they can't tell the difference just by looking at the letters. So I think it's something that we could take a look at in a future meeting. Separately, though, the point that I wanted to just throw out there as a professional member is I've been thinking about the changes to CE that the pandemic has brought and the continued changes that we're going to be going through with CE now and going forward. And again, trying to go back to the simple nature of how do we ensure that doctors are continuing their education in an effective way to protect consumers. I'm not going to name the CE that I was on, but I was on a call, and one of the ways that they ensured that we were still attending is some of the presenters just asked random questions just to see that we were going to respond, and other practitioners were asking actual questions that pertain to the subject. So I thought it was just kind of interesting, because as I was sitting there, I was like, well, one lecturer was just checking to see if I was there, but I maybe was learning, maybe not learning. And another one was actually asking legitimate questions on the subject. And so as we continue through all these different changes related to continuing education, think we always need to keep asking ourselves, are we ensuring that doctors are continuing their education to continue to provide better and potentially expanded scope of care to patients in a safe way? And continuing education, I think, is a pivot point for that. And so we need to always be mindful of that and be watching out for it.
Joe has his hand raised, and then we can talk about Glenn's concern.
Yes, just real quickly, I was just gonna, if I may, throw in that the discussion about the certifications being listed on the license. I definitely am in agreement that we should try to move away from that. There's so many certifications that you do in your practice, like for my site, are we gonna start adding those certifications on the license too? So I definitely think the course we should go is in the opposite direction. But the thing I wanted to originally raise my hand for is that I don't know if I misunderstood, but I thought I heard that some of the immunizations have been processed since the beginning of January. And so I kind of just looked and wanted to go on Breeze to see if, because I know a lot of ODs in my organization have already submitted their applications forward and gotten their check cashed. And so I was just going to see if any of them had their go and process. But the thing that kind of stuck out at me is that when you click on a license lead, the place or the slot where they say what your certifications are, they actually says specialty TLG. And so it's kind of a contradiction there. I just wanted to point out, but that's all.
This is Natalia, Dr. Pruitt. Unfortunately, specialty is what we have to use as the functionality in Breeze in order to make that added to the end of the license. So specialty isn't necessarily a comment on the certification as it is the way we mark it in Breeze to notify it as separate from other modifiers. It's incredibly technical. It's not there as a comment on the certification, rather as a functionality of Breeze, just to be clear. And you actually won't find the immunizations on Breeze or the DCA search because, of course, the immunization process isn't in Breeze. So it's going to be listed separately on the website, optometry.ca.gov, in a Word document list that I'm continuously sending to our web services team to have updated. So that information is available to the public despite it not being available in Breeze yet.
Okay, but kind of just to your point, I understand the technology, but all the more reason to move away from listing the letters because we're talking about consumer protection, and on the ground level, we tell a consumer, oh, well, optometrists can't be specialists. They go and check and look up our license, and it's like, oh, but it says their specialty is TLG or TPA. So all the more reason to try to move away from that.
If I may, Madam President, this is E.O. Murphy. I think we definitely have some legislative history to look into and what we thought we were accomplishing by the prohibition against specialty, and perhaps, as well, our own history in using those it might have been an opportunity to give, some recognition to those additional certifications without them being specialties. So I think that we've got some work to do around what was the original intent in preventing specialties, why we enacted the system of letters, and then perhaps looking at national data to see if there are other jurisdictions, international data as well, if there are other jurisdictions that allow a listing of specialties. And perhaps I kind of hear this all swirling into one discussion. So staff is definitely taking notes on that, and we'll agendize bringing that back to you.
That sounds fantastic. Thank you. And then I don't know, does anybody want to address Glenn's comments about CE? I mean, Glenn, I think my only thing I can say is you can lead a horse to water, but you can't make them drink it. It's the same thing. We now have CE available that's considered live CE for both, in person and also virtual live CE. And the one thing that we did require of all providers who are doing live virtual CE is that they have to check attendance. So if they want to check attendance with a question that actually makes sure that the attendee is paying attention, or if they just want to check attendance by saying, type in the word smile right now, they're still checking attendance because they're supposed to check it at the beginning and end at least. If the participant is listening or not listening, I don't think it's something that we can really make them do. But it's the same thing at live CE in person. I've been to CE where some docs are paying attention and some of them aren't. So I don't know. I don't know if anyone else had any other comments.
Yes. Hi, this is Board Member Sims. I just wanted to comment on Glenn's question. Again, no way to truly guarantee, but by including, and this is maybe one of the benefits of having the online, if you include poll questions related to the subject matter throughout the presentation. And so then people have to respond, and an administrator is there to see who is responding and what those responses are about, or having, short quizzes in between various topics. So those are some of the ways. And then breakout groups are often used for some trainings. I'm not sure if that would, at this point, you probably have trainings that are already set up. So that's probably something to look at in the future. But there are some ways to regulate engagement. Again, no guarantees, but those are some possibilities.
Does anybody else have any questions? Oh,
a question for Sandra. You're an attorney. How's the bar handling continuing education?
Board Member Sims, you're on mute. Or there might be an issue with your connection. Board Member Sims, are you able to hear us? You are on mute.
Can you hear me now?
Yes, we can. Excellent.
Okay, so I can't speak to what the board is doing now. There's been so many changes, particularly since the pandemic, with regard to now, I think right after the pandemic, they had an online, bar examination, which was something clearly that was new for that. But I can speak to continuing education. And with regard to those continuing education, to give you an example, like for sexual harassment training, someone who's doing Title IX training, one of the ways in which we do ensure that type of engagement is we do exactly what I just said. We have those breakout sessions where if we're dealing with a particular topic related to, let's say, sexual harassment, we'll have groups of people go into the breakout rooms. And that's one of the benefits of the online now. And they have to meet and discuss those case scenarios, or we might have a short quiz in between. So those are ways in which we've done it. And as I mentioned too, you might have after a certain topic, a scenario might be presented, and then the participants have to say yes or no to whether or not this is a violation of whatever it is we're talking about. So those are some of the things that we're using just to engage for continuing education.
Thanks.
All right, does anybody else have any comments or questions? Oh, Mark, your hand's raised.
Well, to answer David's question very briefly, we can do self-study and listen to recordings up to, and certify that we've done the CE. I think it's a function of how much we want to proctor these trainings. I get it with the sexual harassment training and other training that Sandra is an expert in. We want to make sure people get the information. When it comes to continuing education, I have very much more relaxed perspective on that. It's, I don't think we need to be looking over people's shoulders to make sure that they're not looking at their cell phones during the CE, or awake, or even learning the material. I mean, they're doing the CE, I think, is sufficient from a continuing education perspective. I don't think we have the energy or the power, or I don't think it's effective be drilling down too hard on the general topic of CE. Sexual harassment, yeah, of course, but other topics, maybe not so much.
You know, I've had more people tell me that with having virtual online live CE that they actually can log on to topics that they're more interested in. So, but it's again, it's up to the individual to, if they really are going to listen and learn or not. I don't think we can force it. Anyone else have any other comments? So I think we now need to go into item number 12, which is, do we have to have public comment for just for what we just talked about?
I think it's fair to ask for it at the end of the, you can sort of cluster the items in this report if that's more practical at this point.
Yeah, so I guess we could have, can we move on to future agenda items and then have public comment after that, or do we need to do public comment right now and then do future agenda items?
Oh, I see. Yes, if you're closing up the report, it would be helpful to at least check for public.
Okay, Madam Moderator, if you could open up Q&A to have public comment on item 11, the Executive Officer's Report, please.
Thank you, Madam President. I've opened up the Q&A panel. If any member of the public would like to make a comment, please type comment using the field in the lower right-hand corner of your screen and submit it to all panelists, or you may simply raise your hand. We're displaying instructions and we'll give you a moment. All right, I see no request for comment at this time. Shall I close the Q&A panel?
Yes, please.
Okay, it's closed.
Okay, we are now going to move on to item number 12, which is future agenda items. Does anybody have any topics that they would like to add for our May 20th meeting? No? Madam Moderator, if you could open up Q&A for the public to make a comment about any future agenda items, please.
Thank you. I've opened up the Q&A panel. If any member of the public would like to comment on future agenda items, please type comment using the field in the lower right-hand corner of your screen and submit it to all panelists, or you may simply raise your hand. We're displaying instructions and we'll give you a moment. All right, I see no requests for comment at this time. Shall I close the Q&A?
Yes, please.
Okay, it's closed.
Okay, so we are now just moving on to item number 13, which is closed session. Rebecca, you're going to be with us in closed session, and then who from staff is going to be with us?
I think your moderator is all set to get us into closed session with the appropriate staff, and then.
Okay. And then just to let the public know that from closed session, we're going to be adjourning the meeting. So we will not be returning to open session to close the meeting. Okay, so if we could just go ahead and go to closed session, Madam Moderator. I can't talk anymore.
Thank you, Madam President. I am just cleaning out the panel list of people that should not be in closed session. So I'm just changing their role, and I can only do it one at a time. So it's just going to take a little bit of time. If you can give me a moment.